Okay. Hello, my name's Steve Tarrett, and I'm very pleased to welcome you to the BLC Box. And I'm extremely pleased to be joined today by Professor Allison Young, who is the Sir David Williams Professor of Public Law at the University of Cambridge. She's also a Fellow of Robinson College, Cambridge. She co-edits the UK Constitutional Law Association blog, which I highly recommend, publishes extremely widely on all aspects of the UK Constitution, and she also is a co-editor of Public Law and European Public Law. So thank you so much, Professor Young, for joining us today. I'm really excited about being able to chat with you. Thank you.
Thank you for asking me. It's a pleasure.
Well, I'm sure it will become an incredible relief to our BLC students who are from all across Central and Eastern Europe to have a renowned expert who can at last explain to them how we can have a 21st century country that can function at all without things being written down in a nice, easy to understand single document. So maybe we can begin there. How on earth can a country function without a written constitution?
I guess the cheeky answer in some senses is to say we've been doing this for so long now, it just seems normal. I think that the basic way to see it is that we don't have a codified constitution, you're right. So you can't go off to a library, pick up a book off the shelf that says UK Constitution and find all the rules in there. But to see it as unwritten is a bit of a mistake. We've got lots of sources of the Constitution that we rely on. So we rely on things like legislation, we rely on things like the common law, and yes, we do rely on things like conventions, which are for the most part not written down, not enforced by the courts at all. So that does seem very odd to think a huge amount of how we operate can just come through these rules that are practices that are enforced by political means. And I think the way to see it is just how they all lock together, if that makes sense. So we do have conventions playing quite a large role. So we don't have anything in the Constitution or in the law, for example, that says this is the Prime Minister, this is how you nominate or elect the Prime Minister, and these are the powers the Prime Minister has, and these are the ministers they appoint. Instead, we just have a convention that says whichever party has the most votes forms the government, and the leader of that party becomes the Prime Minister, and that Prime Minister can work out who the ministers are going to be and then goes to appoint them, and he can change what departments they run or anything. So that can look incredibly odd. I think it gives us flexibility, and the way in which it works is because of that element of, well, the government only has the power to the extent that it has the confidence of the House of Commons. And if the House of Commons, which has been elected by the people, is not happy with the government, then it can vote them out. And that's kind of how we see it as working in a sense. And then we just supplement it by having rules that are there. So we have things like the Human Rights Act, we have things like the Fixed Term Parliaments Act, which sets the term of a particular sense of Parliament. We also have things like the Parliament Acts 1911 to 1949, which sets out the roles of the House of Lords. And so we have this, it's because it's got this amalgamation of so many different sources that it manages to work, even though I completely understand from anyone outside the UK, it just looks completely odd. You begin to wonder, how on earth can it work if we can't just go away and find the rules? And the answer is somehow it does. I think it's probably the best way of looking at it.
Well, not only strange from the perspective of students from Central and Eastern Europe, but I remember when I studied constitutional law, which was a while ago, but we're not talking centuries ago, no one ever mentioned to me the idea that there were constitutional statutes, that some statutes were more important than others. In fact, quite the opposite was we didn't have referenda. There was never any statute that required a 2/3 majority vote as the fixed term parliament did. Exactly. So what's happened since I left the UK?
I think a lot of what's happened is we've started to begin to think much more about what we mean by a constitution, what these constitutional principles are. And we've seen this starting through legislation that started to enact provisions for the constitution. So things like the Human Rights Act or the devolution legislation that set up how we devolved power. And then obviously the other thing that happened was we had to somehow reconcile how can we be a member of the European Union when we were a member and allow the primacy of directly effective EU law if we then say, but actually Parliament is supreme and any law it enacts can overturn any other law. And one of the ways out of that dilemma was to say, well, what if we had constitutional statutes and these constitutional statutes couldn't be repealed in the same way? You had to have very specific words or very express words, and then we could make sure that EU law override normal laws, because obviously unless you had a provision saying notwithstanding EU law, which is just not be able to act politically, then you couldn't overturn it. So it started with trying to find a way of resolving having something that needed to perform the role of a constitution while still having parliamentary sovereignty. And then from that, the courts have just been developing more and more this idea of constitutional statutes, which means if a piece of legislation is constitutional, what is odd is the courts tell you that. So it's not that it's been enacted in a different way or that the legislature has said, oh, this is a constitutional piece of legislation. The courts will identify it as a piece of constitutional legislation, say that this is therefore more important, and then say, if you want to overturn it, you can, but only if you've got very clear, specific and express words to overturn those provisions. And we've just seen this developing incrementally over time. And it just was there originally to solve that problem and now starts to attach to all sorts of other pieces of legislation, like the Human Rights Act and like the devolution legislation, for example, which is also seen as constitutional.
Okay. Now the very origins of parliamentary sovereignty make sense in the historical context that they came from. So Parliament versus the monarch. But the threat that most people see today is from their very Parliament, perhaps entrenching on human rights, etc. So is the time ripe for a rethink? Should we have parliamentary sovereignty in a world where Parliament is most likely to be infringing my rights rather than Queen Elizabeth?
Well, I think in some senses I can understand where the problem is coming from. It's not the case, I think, now that the Queen is suddenly going to go away and start taking all our rights away, that the bigger threat does come from aspects of what if you do end up with, say, an election that delivers an incredibly strong government that wants to remove rights, that wants to take human rights away. And the kind of traditional response from the UK perspective is to say, well, the way in which our political system works makes that unlikely, and we can discuss whether that's really the case or not, and B, there are mechanisms that the courts have to try and make sure that if this legislation was enacted, then it wouldn't necessarily always take away your rights. So, for example, you mentioned the idea of constitutional legislation. A lot of the legislation protecting rights is seen by the courts as being a constitutional statute. So the Equality Act 2010, the Human Rights Act 1998. So we would look at that and say, well, unless you have very, very clearly and precisely expressly said you want to take these rights away, then we won't let you. So that's one mechanism. The other is the way in which courts interpret legislation. So the courts have developed something called the principle of legality. And this is where they say there are fundamental principles of the common law. And these fundamental principles of the common law can only be removed by very clear, precise, express and specific wording. So in particular, if you give a general power to the executive, to the government, and they use that power in a way that undermines a fundamental common law right, the courts will say, you didn't have the power to do that. You can't remove this fundamental common law right, and they'll stop them doing so. And they will do that by reading the legislation so as it doesn't harm rights. And we also have dicta from the courts that if we were in a situation where Parliament did something unthinkable, like completely remove the ability of courts to protect individual rights, or to do something which completely undermined the franchise, so it was no longer a democratic system, then the dicta, which is not legally binding, so it's just a kind of suggestion of what they might do, but it isn't quite law, if that makes sense. then the dicta says that in those circumstances, the courts just might not recognise that as binding law. So it's almost like a kind of sort of system of, we know you could do this, but we don't think you will because the political system will stop you. And if it didn't, in those extreme circumstances, you will find that we will probably stop you, but we haven't had to yet. It's a kind of an odd sort of system of kind of managing it in a sense, but that's kind of how we kind of see it. So the question is that enough? And I guess the real answer to that is, who do you trust? Do you put more trust in your democratically elected officials and a democratic system of government to not enact these laws that would become, laws that remove fundamental human rights? Or do you put more trust in your courts with the documents setting out what those rights are to protect them? And historically, the UK has put more trust in Parliament than it has in the courts. And so that's why we've ended up with this system. Whether that will continue, I guess really the answer is only time will tell. And if you get to a situation where we do see perhaps these laws enacting, I think that will be one of those moments when the UK will take a step back and say, I don't think we can trust parliamentary sovereignty anymore. And I think that would be when we would think about setting up a different constitutional structure.
Right. Okay. Thanks. Well, you mentioned essentially the question of trust and potential conflict between Parliament and the courts. We've had a couple of cases in recent years where that conflict has come very much to the fore. And if we throw the government into the mix as well as something separate from Parliament, yes. Then in the first Miller case, the UK Supreme Court was asked to rule on a very political and yet legal question. Yeah. Although I remember people being divided about whether this was even a legal question. Could you maybe just say a little bit about the Miller case?
I will. So obviously, the first Miller case was the case where the government obviously had the referendum outcome, and so it needed to go away and communicate to the European Union the UK's desire to leave the EU. And so the question arose was, well, do you have the power to do that? Where does that power come from? And in the UK, the government has two main sources of power. One, which most people will understand quite easily, which is it comes from legislation. So Parliament will enact legislation and delegate the power to the government. And the other, which is the one that anyone outside of the common law UK system finds distinctly odd, is the royal prerogative. So these are powers that have belonged historically to the monarch, that have become sort of transferred away from the monarch towards the UK government, so towards UK ministers. And traditionally, as historically, what has been part of those prerogative powers is the power to enter into foreign relationships. So the power to enter into treaties has definitely been seen as part of the prerogative. So the government assumed, well, if it's a prerogative power to enter into international relationships, then surely it's also a prerogative power to withdraw from an international relationship. And as I discovered in Miller 1, that wasn't necessarily the case. So the question that arose was, do you have that prerogative power? And the way the court looked at it was to say, well, yes, you do have these broad prerogative powers to enter into treaties, and they will also include the element of withdrawing from treaties, but these broad prerogative powers are just not unlimited. There are certain things you can't do with a prerogative power. And one of the things you can't do with the prerogative power is change domestic law. So if triggering the decision to move the EU would change domestic law because it would remove all the rights that you have in the EU, or you have rights you have in the UK as being part of the EU, then that couldn't be done by prerogative alone. Also, the other thing you can't do with the prerogative power is frustrate the legislation. So you can't do something that would kind of undermine or stop you being able to use your lawmaking powers. And so what the Supreme Court had to conclude, what it had to look at was, okay, if you withdraw from the EU, will this remove domestic rights or will it frustrate legislation? And if it does, you can't do it with your prerogative because it doesn't go that far. But if it doesn't, that's absolutely fine and you can use your prerogative. And as we know, they said, nope, no prerogative, you have to go away and use legislation to empower the government to act here. Yeah.
And why was it that the government was, if I say afraid, perhaps that's much, but why didn't they just adopt legislation in the first place?
Well, I guess the concern is that if you have a prerogative, then it gives a very large discretion to the government. So it essentially says you can go and withdraw from the EU treaties when you want, as and when you want, and that power is unlimited. But if it's from legislation, then there's a possibility that Parliament then has to enact a piece of legislation that empowers the government to act. But Parliament could have said, yes, you can do this, but not until you've had another referendum on the kind of EU we want afterwards, or you can only do this if you guarantee that you will protect the rights of EU citizens currently living in the UK, or you can only do this if, when you've got an agreement, we vote on that agreement and tell you we agree with it. So they could have put conditions on how the government exercised the power. So it was much easier to say, well, we'll use the prerogative and then we can go away and do this, rather than having to go to Parliament, coming up with legislation and running the risk that Parliament might vote against it, or will put conditions on those powers and limit what the government could do.
Okay. So, but are there still other aspects of Crown prerogative where, notwithstanding the Miller judgment, that for example, the Prime Minister can appear in front of Parliament and use this prerogative without it being debated in Parliament?
Mm-hmm. Yes. I mean, this is the aspect. I meum, prerogative powers, there's very little ability for Parliament to control how a minister exercises a prerogative power. We saw that partly with the Miller 2 decision with the power of prorogation, which kind of just suspends Parliament, where you just sort of turn up and say, I'm suspending Parliament. The end. There's not much of an ability for Parliament to sort of debate and say, well, you can only do this in certain circumstances or under certain conditions. And that's the other difficulty with prerogative powers. If you have a piece of legislation which empowers a minister to act, and it's through delegated legislation, then often that delegated legislation has to be laid before Parliament. Parliament could vote against it, or Parliament might have to agree to it for that delegated legislation to come into place. Not the case with prerogative powers. You can just go and exercise them and off you go. And all really Parliament can do afterwards is question you and say, well, why did you use your prerogative power in that way? Which is not really much use once they've already used it. So we don't like what you did there, please don't do it again. It's not really a very effective way of controlling how you use a prerogative power, which is why I think the two Miller cases are so important, because it's increasing the legal controls over these prerogative powers, because without legal controls, there's very little political control over them. So in a sense, having that legal ability to say, well, this is what the scope of the prerogative is, and this is, there might be some conditions in some circumstances over how you can use them, just makes, provides a way of limiting that power that might not be found through political means.
Okay, and now the Miller judgment was not a unanimous judgment, no. Or Miller 1 was not. Mm-hmm. What was the essence of the counter argument that was made?
So what they were disagreeing about was how you interpret the European Communities Act 1972. And so we've said that if the prerogative would have removed or changed domestic law, then that would be beyond the scope of the prerogative. So the big question was, all of these rights that we have in the UK that we get from the EU, are they EU rights or are they domestic rights? And so they were trying to argue about, well, how do we classify these rights? And this required them to think about, well, how does EU law become part of UK law? And so we know that because the UK is dualist, for the EU law to become part of UK law, there has to be a legislation bring it in. And that's the European Communities Act 1972, which was the way in which EU law became part of domestic law. They then started arguing about, well, when does it become domestic? So it's a bit like imagining you've got a kind of pipeline between the EU and the UK, and all these rights are coming through the pipe and landing in the UK. And the question is it the case that the EU makes the laws and they kind of travel through the pipeline and they don't really become domestic until they've been kind of come through the European Communities Act 1972? So in essence,
Mhm.
they're not really domestic rights, they're kind of EU rights that have, and once you get rid of the act, they're not there anymore and it's fine. Or do you see them as becoming domestic rights in a sense, almost like the moment they're made in the EU, because the UK has recognised that these rights are now part of domestic law through enacting the European Communities Act 1972. So it's a bit like, are they sort of, the EU makes them, and the moment they enter into the pipeline to get through the UK, they're domestic, or do they not become domestic? It's a very technical thing they were arguing about when the law becomes EU law, and it's because the UK is dualist. And they were concerned that if we see the EU rights as being essentially domestic rights from the moment they're enacted, because the UK has recognised this as a source of law, does this mean that in a sense we're no longer dualist because we're allowing them to be recognised from the beginning? And that's why they were arguing. And another aspect of that argument about the legislation was, is this going to frustrate the European Communities Act? And that was really a kind of disagreement about what they thought the European Communities Act was. So the majority see this as a piece of legislation that incorporates the EU into, makes the UK a member of the EU, incorporates EU law into UK law. And so it's all about recognising EU law as a source of law, and its whole purpose is to make us part of the European communities. So the moment you withdraw, you frustrated the purpose of the legislation. But the minority looked at the wording, and the wording of the provision tells you that all principles, liabilities, immunities, rights in EU law arising, and this is the crucial words, from time to time, become part of domestic law. And they said, well, because it says from time to time, it's whatever is the EU law we have to comply to at the time. And if what we have to comply at the time is nothing, because we're not part of the EU anymore, then it's not that the European Communities Act is frustrated. It's just we don't have, at this time, none of the rights come through. And that's, so it sounds, when you're trying to explain this to students, they kind of look at you and go, well, but this is a really technical thing that they're disagreeing over. And they're absolutely right. But it's because the real disagreement was, how do we interpret this piece of legislation? And if we interpret in this way, will it challenge the whole idea that the UK is a dualist, not a monist country? And that's what they were essentially arguing about when they were disputing about whether, if we left the EU, we would remove domestic rights. And if we left the EU, would we frustrate the purpose of the legislation? So it's, when you try and explain this, it just sounds, you try and explain it as best you can, and people kind of look at me and sort of say, why were they arguing over these technical differences? But I'm afraid that was what they were arguing about in the case.
Well, that provides a nice contrast, though, because as technical and as legislative as the interpretation was in Miller 1, then Miller 2, everyone understood at least the story behind it. It was Boris versus Brenda, or
exactly.
the versus the Supreme Court. So could you maybe just continue the story and bring, 2 years later, the government is again in litigation.
That's right.
With Miller 2. So what was happening there?
Okay, so you set it out very well. It's seen in the UK as the triumph of the spider brooch, because of the brooch that Lady Helen was wearing at the time she gave the decision. But it was, so the whole context, you said it very well. So this was in the run up to what would then have been one of the days in which the UK would have left the EU, the 31st of October 2019. And there'd been a whole series of debates in Parliament to try and vote in favour of the withdrawal agreement, such that we could then leave with the withdrawal agreement. And it got to a stage where that clearly wasn't going to happen. And so the government's policy was really to try and leave with no deal. And one of the ways of trying to achieve that, at least the Prime Minister said this on television, but when he was asked about why he prorogued, he said it was to try and set up his new Queen's speech. So one of the ways of kind of moving there was to prorogue Parliament, which is an odd thing to kind of explain. So the power of prorogation, it rests with, it's a royal prerogative. So it rests with the Queen, and the Queen is asked to prorogue Parliament, and she will normally act on the advice of her ministers. So Boris Johnson advised the Queen to prorogue Parliament. And what we mean by proroguing is, in the UK, we have a fixed term of Parliament for 5 years, but we split that up into little sessions. And what prorogation does is it ends one of those sessions in that term of Parliament. And if you end a session, all the parliamentary committees they stop. All the parliamentary committees that were sitting just stop. They don't sit anymore. The House of Lords doesn't sit anymore. So everything in Parliament stops, and all the legislation that was going through Parliament that hasn't managed to make it to the end lapses. So you'd have to start again in the next parliamentary session. So it's quite a large impact if you prorogue Parliament. So the Prime Minister decided to prorogue Parliament for 5 weeks in the 8-week period running up to the exit day of 31st of October. And so the question was, did that prerogative extend that far? So did he have the prerogative power to do that? And then before we got to the Supreme Court, they were arguing about it by saying, well, he does have the power, but he's used it for an improper purpose. He's used it to try and get us out of Brexit with no deal, rather than using it in order to just get a new Queen's speech going and set up a new session of Parliament. And so when this caused all sorts of issues of, well, can you do that? Is this something the court should be looking at? Isn't this just too political? It's not really legal, so why is it even getting that? And when it got to Supreme Court, the court decided it in a different way. So it never had to ask itself whether it could judge this prerogative power or not, because it said, well, the common law puts limits on the prerogative. So before we even get to, was this an improper purpose, we have to say, did you even have the power to do this? So what are the limits on the prerogative power of prorogation? And they looked at background constitutional principles, parliamentary sovereignty, parliamentary accountability, and they said, okay, these common law principles put a limit on the extent of the prerogative power of prorogation. You can't use it in a way that would be a really serious impediment of parliamentary sovereignty or parliamentary accountability unless you give us a good reason. And they said, because this had stopped Parliament for 5 weeks in the run-up of 8 weeks on a really important issue where Parliament was meant to play a role, we see that from the European Union Withdrawal Act provisions, then this was a very serious breach. There was no reason, so there's this wonderful statement where Lady Hale said that there's no reason, let alone a good reason, had been provided, so they didn't have the power to prorogue, and the prorogation was quashed.
So if, of course, we're speculating here, and this would be completely obiter dicta, but if the government had given a reason, and then how much of a margin of discretion do you think the court would have been willing to give? Because I think we all know why the government didn't want to have its negotiations complicated by ongoing debates in Parliament. But how convincing a reason must it have been? Because people must have been kicking themselves within government. We should have said something.
We should have said something. I think they would have been quite deferential, because they did recognise that this was something that is quite controversial, that it is normally controlled by political means. And so they're very careful when they set out the limits on the power of prorogation to point out that it really has got to be a sufficiently serious breach for us to decide that we, the court, should be intervening. So it was the whole context. So you could see they were being quite careful. And I think if there had been a reason which they felt was not, manifestly wrong in some sense. So we have this, so if there was some justification there, where there was some kind of reason that they could see that wasn't completely unreasonable, wasn't manifestly without reasonable foundation, my guess is they would have been quite deferential and said, well, that's enough. I think the fact it was easier for them because there was no evidence provided in court with an affidavit to say, well, this is why, this is our justification. And in some senses, in weighing up the certainty, the weighing up the element, I think, well, you don't, if it's just for a Queen's speech, there's no real need. I mean, they had evidence from Sir John Major, former Prime Minister, in the court that was basically saying, well, we've never really needed 5 weeks to come up with a Queen's speech. So And I think that context as well suggests that, you know, if there'd been something that wasn't sort of manifestly without grounds, I think they would have been quite differential there, yes.
Now, early on in the Miller 2 judgment, I think Lady Hale says this is a one in a lifetime style judgment. This won't happen again.
Yeah.
And yet the underlying, those who didn't like the Miller 2 judgment questioned whether this was the floodgates beginning to open about the Supreme Court stepping up and acting like an American style Supreme Court in the absence of written constitution, that the court stepped up. How do you see that? Some people were afraid of the Supreme Court being too overactive. Was Miller 2 an example of over exaggeration of the court's role, or was it what the court should be doing?
Okay, well, I'm one of the people who would argue it's what the courts should be doing. So I'll explain why I think some people think it's going too far, and why I think, particularly in Miller 2, that that's not the case. So I think the reason why some have criticised the judgment is because they just see this as being something that is so political, then really we should just rely on the monarch saying, well, actually, I know I'm supposed to act on your advice, but this is ridiculous, I'm not going to. Or we should rely on Parliament, who could, knowing that prorogation was going to take place, could have had a vote of no confidence and voted them down. And so the suggestion is that these are just too political, that political mechanisms are there, and if people don't use them, then it's not for the court to step in. And then they also argue and say, and they drew on constitutional principles. So it wasn't like the court was saying, here's a piece of legislation, here's another piece of legislation, this is what we think it means. They went away and said, there are two fundamental constitutional principles: parliamentary sovereignty, which it interpreted in a kind of broader way to see it as needing to protect the powers of the legislature, and parliamentary accountability, which it sees as this aspect of the legislature having to hold the executive to account. And particularly the second one, that there are hints of this in cases, but this has never really been discussed up front in a court case before. So their criticism is, look, this is just too political, and when you're going away and doing this, you're drawing on these fundamental principles that no one really knew necessarily were there. So surely you're just creating this, and this is going beyond what the court should do. And I would argue against that in two ways. First, I don't think it's too political if all the court is doing is not sort of weighing up the reasons. It's not as if the court was saying, here are the reasons for proroguing, here are the reasons against proroguing, this is what we think is more important. The court was saying, look, there are some instances where you have such an impact on the fundamental operation of democracy that we have to intervene. And they were very careful to say it's got to be sufficiently serious. It's not that we're going to wade in on every single prorogation and say, oh, I'm not so sure, 10 days might be a bit too much, maybe you should try 5. It has got to be something very, very serious. And I think they were very careful to say, this is an extreme circumstance, this is a very extreme set of facts, which is why I think in those instances, I think there are legal limits at the extremes that the court should be enforcing. And second, yes, I can see why people think the courts are drawing on these background constitutional principles, but the courts do this all the time, and it's their proper role to do so. And I think what's really important about the way in which the court decided Miller 2 was it didn't do this in order to give more power to the court. So at no stage did the court say, oh, and now we're going to strike down legislation, or we are going to tell you what all these human rights are, and if you transgress them in any way, Parliament will stop you. Instead, the court here was stopping the government from usurping the will of Parliament. And I think that's really important to put it into that context, that much as you could say, well, Parliament might have been able to have a vote of no confidence here because there's a bit of time, you have to put it in its complete political context. Parliament didn't want to leave with no deal, so it spent its time enacting a piece of legislation to prevent that, rather than having a vote of no confidence. And that, for me, is a valid political choice. And to almost like force Parliament into saying, well, you should have had a vote of no confidence, and if you didn't, it's your own fault and we're not going to wade in, it is almost in a different sense taking a political choice, which I don't think the court should be doing. Here, they looked at legal principles, they protected the Parliament in a situation where Parliament wasn't necessarily able to protect itself, and they upheld democracy without necessarily giving themselves more powers. So for me, I think it's a justified decision, though I can understand why people might think it was too political. Personally, I don't think that's the case.
That's great. Thank you very much. Maybe returning to the political then, and to Parliament. Then one aspect of post-Brexit life is that, of course, there are going to be huge swathes of law that have been traditionally, or for over 40 years, regulated by the EU or influenced by the EU, and now EU law has gone, and part of taking back control implies that you must want to change some of this. Well, I read that the Scottish Parliament has described the manner in which this will be done as amounting to a power grab by Westminster. So could you explain to us what is it that argument is about?
Okay. So this is all about the way in which we repatriate powers, in a sense. So at the moment, when you're part of the European Union, then as you rightly point out, the European Union enacts lots of laws. And although the UK Parliament has exclusive power to deal with sending people up to the EU and when we're a member and sort of dealing with international law, when you have EU law like a directive that can be implemented, if it's in an area that's being devolved, then each of the different devolved governments gets to implement it themselves. And so particularly because things like agriculture and fisheries is devolved, in the EU context, that can be quite a lot of power that is devolved down to the different devolved governments. And originally, when we were enacting the European Union Withdrawal Act 2018, the original assumption would be, rather than the powers going to the devolved area, to the devolved governments, they would all go to Westminster for 2 years, and then they would go back to the devolves. And of course, anything enacted by Westminster in that 2-year period couldn't then be contradicted later on by the devolved government. So in that context, you can understand why Scotland will say, well, this is a power grab. We have been used to enacting powers in the devolved areas, but rather than coming back to us, they're all going back to you. You're going to set a whole lot of rules, which we then can't contravene. And so this then led Scotland to enact its own Continuity Act, its version of how do we get EU law to continue in the UK. Eventually, the withdrawal agreement, the Withdrawal Act swapped it around. So now the 2018 Act does put the power in the hands of the devolved governments. Okay, so it's reversed it, but the UK government reserves the right by delegated legislation to decide that some areas should be done by Westminster rather than the devolves. And it can, by delegated legislation, say, well, we'll act power in these areas. But the legislation says they have to get consent, but it's defined consent in a strange way, because consent just means ask them. And if they say nothing, or if they agree, or the favourite, even if they disagree, they've consented. It's the weirdest kind of, it's the one piece of law where no means yes, it's absolutely fine. And then the UK government will enact delegated legislation in that area, and again, that will then, they will then say, well, we're going to enact provisions in this area, and again, they will then restrict the delegated bodies from contravening. And so you can see, even after the change, it's still perceived by Scotland to be a little bit of a power grab, because they don't necessarily have to consent to Westminster deciding to legislate in that area. And that's created a lot of tension, because instead of the powers coming back, they might now find, and you can act provisions in these areas as long as you don't contravene EU law. Now you've got the situation where the powers don't necessarily come back to you, because the UK government could decide, well, it wants to enact laws in those areas, not the devolved bodies, and that's why it's seen as a power grab. So it's partially resolved, but still not fully resolved, which is why Scotland didn't give its consent to the 2018 Act. and neither Scotland, Wales, nor Northern Ireland gave their consent to the 2020 Act, which implements the withdrawal agreement. So I try and explain this to people from continental systems that, you know, by convention they consent, but even if they don't, it doesn't matter. The law comes into force anyway, and this just seems to make no sense.
My children would like the same rule to apply if they say, "Can I have some dessert after dinner?" That you must ask Dad.
Yeah.
Regardless of what he says, you just help yourself to the pudding.
You can have it. It'd be great. It'd be lovely if that was what consent meant, wouldn't it?
Well, something you said raised another issue that very often our students can leave students wide-eyed in the countries where we teach, because apart from having a constitution where the court can overrule primary legislation, there is also a very clear hierarchy between primary legislation and secondary legislation. And never could secondary legislation be used to change primary legislation. But we have someone, Henry VIII was famous not just for his wine, but for giving his name to certain types of legal clauses. So could you maybe say a little bit to us about Henry VIII clauses and how they
I will. Yeah, so Henry VIII clauses are clauses where the government is given the power by delegated legislation to overturn primary legislation. Which, yeah, if you're used to a hierarchy, yeah, exactly. And we kind of see it as, but if Parliament is sovereign, and if Parliament has said that the government can use its delegated legislation to overturn primary legislation, that's fine, because Parliament has told us this. And so, you know, that's okay. And there's been a lot of concern about them. So it's kind of, sometimes we're not concerned about them. So one Henry VIII clause that no one is concerned about is found in the Human Rights Act. And that allows the government to kind of fast track through an amendment to primary legislation to bring it in line with convention rights. So if you've had a decision of the European Court of Human Rights that says this bit of UK law is not compatible with the convention, or you've had a decision of the UK Supreme Court that is declared under Section 4 of the Human Rights Act that something is not compatible with convention rights, then you can use delegated legislation to amend the primary legislation to bring it in line with convention rights. And we don't see that as a problem. If it's obvious where the breach was and it's obvious how to resolve it, then we think, well, by all means, get the government to do this quickly, because this is a good thing. It's protecting human rights. But the problem we have is Henry VIII clauses are almost everywhere. So this is particularly true in the European Union withdrawal. I'll get to the European Union Withdrawal Act. So we get confused because one is the EUWA and one is the EUWAA. So we always get confused as to which one. So this is the 2018 Act, which helps you to deal with EU law becoming part of domestic law. And this gives a huge Henry VIII clause to deal with deficiencies in EU-derived law. And it's not just a problem that's a Henry VIII clause, so a minister can override primary legislation, but he's empowered, he can do this when he considers it appropriate to do so. So this is this huge power to then go away and do this. And the only real check on this is, well, you have to have affirmative resolution procedure, so Parliament has to agree to the delegated legislation you enact. And most of this has been seen as justified because you're just dealing with technical issues, sort of taking out EU patent agency and instead inserting UK patent agencies or something along those lines, which we see as necessary. But the danger is, but what if you start making policy choices, which in order to and then you're overturning parliamentary legislation, making a policy choice that Parliament hasn't really scrutinised. And even with the affirmative resolution, there's so many of these going through. And there's been hundreds and hundreds of these going through in a very short period of time. It's very, very difficult for Parliament to keep track of what's going on. And I think it's, so much as we try and justify them and say, well, we need this to enact the law quickly, or to, you know, under the Human Rights Act to bring things in line with human rights, the danger is you can pass a huge amount of delegated legislation with very little parliamentary scrutiny, which starts overturning legislation left, right and centre without you realising this is going on. And I can understand why, if you're not used to, well, Parliament said it was okay, so it's fine. It's incredibly, from a separation of powers point of view, it just looks wrong.
Absolutely. And from the flip side, again, returning to my student days, I remember my professor saying, you don't need to worry about secondary legislation because the courts can always use the ultra vires doctrine.
Yeah.
And if the minister has overstepped their powers, they can,
Yeah.
if the power given to a minister, the only question they have to ask themselves is, do you think it's necessary? Then it doesn't seem like the courts have much power to these things either. Well, it seems we will continue to have some wide eyes in Central and
I think so.
Well, maybe I could just finish. I'll throw two questions together that I'm sure our students would love to know. I remember, again, returning to my student days, the constitutional law book was one where it wasn't updated every year. You could probably buy one for the first year students. And when we join and I say to students, what do you think about the English Constitution and history? And they will always say, stable, never changes, solid. And now you must be, by the time the ink is dry on your textbook, you must be writing the next one because it's changing at an exponential rate. So over the last few years, we've had a number of whether the Human Rights Act or devolution and Brexit and then post-Brexit things. What do you think we've learned about the UK Constitution, and what do you think we will continue to learn? And do you think that our lessons will ever take us on that path that would make all of our students very happy? Will you ever have a written constitution, and will that ever for the UK?
Okay, so I think the kind of what it tells us most about the UK Constitution is just how flexible it is, and how things that might cause a constitutional crisis or be very difficult to resolve can be resolved quite, flexibly and pragmatically in the UK Constitution, and it can change form quite rapidly and quite quickly, which hence, we do joke now that being a constitution lawyer, you may as well just be a journalist. It's changing so quickly. It's like, it's you can't keep up with it. It's not, it's every day something new seems to be happening, and at least it seemed to be that way in 2019, where just everything happened every day. But it shows the flexibility, and it shows the adaptability of the Constitution. But I think it's also shown that the Constitution is there and is alive. I think a lot of the time when you think of the UK Constitution as being very historical, of having had the same principles all along, of never really changing, I think this is really brought to the forefront that it is there. It does play a role, that the courts are willing to use these long-standing constitutional principles to make sure that government and the executive don't just act within the law and uphold the rule of law, but also act within the background of these constitutional principles and act in a constitutionally appropriate manner. So I think it shows us a lot about that, and it shows us a lot about how so much of it now is written. So things like the Human Rights Act, that we are becoming more and more written, and we are becoming more and more legal. But I think it's also illustrated some of the dangers that we haven't known the answer to these questions. So to have a situation where you're saying, well, I don't know if the government can do this or not, just seems very odd when you're used to a constitution that tells you what the powers of the government are, and you can just go away and find them. And yes, any constitution will have some flexibility, but to kind of almost be at the stage where you've got such divergence over whether someone does or does not have the power to act, I think is showing some of the downsides of having this flexibility, that you might not know whether you have the power to act, and there might not be the kind of checks and balances that you need over those powers. And much as the court can intervene, it will be criticised sometimes for intervening because it seemed to be doing something political, because the court can't turn around and say, but I'm just upholding the law, or this is my constitutional document, that's all I'm doing, I'm not doing something illegitimate, you have set these principles and I'm just applying them. So there's a danger to it as well. Will we ever get a written constitution? I think that the UK is so used to pragmatically working its way through things, and then looking back and thinking, well, that more or less worked, so it's not broken, there's no need to fix it. And I think That is very much kind of influencing. I mean, I think it would take a real constitutional crisis, a crisis which couldn't be resolved either by court cases or by internal political struggles, for us to actually get to a proper written constitution. I think we're moving towards that incrementally and slowly, and it might be particularly because of the way in which we are going to have sort of shared powers after the end of the completion date, where you've got powers where both devolved bodies and UK bodies can be acting in the same area and having to work together, that I think we might start to think about, well, will we need to move towards a constitution, because we'll need to try and shore up kind of a more federal rather than devolved structure. I think that might be the aspect that pushes us towards thinking more about a written constitution. There's not much of a political will at the moment with the current political party, the Conservative Party that's in power, to move towards entrenching human rights. I mean, they would, I think, move more in the other direction. So I don't think we'll see a move in that direction. But I think where we might see more pressure towards a written constitution in the near future is to shore up this aspect of maybe moving towards federalism and dividing the power. I think that in a lot of ways would be an advantage. I think there's a lot of tension that's being created through Brexit, because you have had these accusations of power grabs, being able to enact law without consent, which I think is very problematic. And I think that would be an improvement. Whether we'll ever go beyond that, I'm not really, probably not in my lifetime, I think is probably my guess.
Well, I hope that if we do, that you will still be writing textbooks to explain it all to us, because
I'd love to.
You made some very difficult issues very clear and very enjoyable and fun to talk about them as well. So thank you so much for having joined us. It's been an absolute pleasure. And when Miller 3 or 43 or is being discussed, then we'll be back in contact and asking you for your opinion. On behalf of everyone at the British Law Centre, all of our students from all over Central and Eastern Europe, thank you so much for joining us.
Thank you. Thank you so much for inviting me. It's been very enjoyable, and I hope one day to be able to visit in person when all the lockdown measures have been lifted.
Welcome, absolutely. Very much welcome. Okay, take care then.
Thank you. Bye. Bye.